we can please come to order. We have a quorum. We have an agenda. If you want to be heard on a bill, please come sign up in the front. If you can please come to order. If you can please take your conversations outside.
All rise.
Or that. We got to get started because it's late, as everybody knows. If you're going to get food, at least try to do so quietly, please. All right. Chairwoman Cooper, will you please come up? We're going to start with House Bill 470. We are working off of LC 3. I'm getting all out of order. Let's ask one of our newest members of the committee as he takes one more bite. Chairman Harbin, will you please open us up in a word of prayer? What's your mic number? 14. We already heard Jesus Take the Wheel was our playing that's on the start. It's been the theme of the day. So if you can echo that in your prayers.
You got it, sir. All right.
Y'all will please bow with us.
Let's pray. Lord, we thank you for the day that you've given us. We thank you even for the night. We thank you for life itself. And, Father, for the privileges that we have, dear Lord, to rule ourselves even. And we ask, oh, Father, that you would give us wisdom, discernment this evening, that, Father, we would represent the people of Georgia justly and rightly. And we ask for your wisdom in Christ's name. Amen.
Thank you for that. All right. House Bill 470, this is the Candor Act bill we heard last year. We have some new members on the committee. If we had more time, I'd have you introduce yourself and say where you're from and everything, but we don't have time. But this is the same bill we heard last year. I believe it was unanimous in committee. If you can briefly tell us what the bill is, and let's just see if we have any questions and see if we can get it moved. Chairwoman Cooper.
Thank you, Mr. Chairman, members of the committee, and thank you for allowing Mr. Snipes to sit here with me since I'm not an attorney. This is like an extension of our good...
Sorry, go ahead. I forgot to tell you about the jar.
What jar?
Well, we have a jar up here
that
while we are kind of in a hurry because it's late, we will stop to acknowledge the jar. And some people like to go in front of our committee and say, I'm not a lawyer, but, or something close to that. And when they do that, they have to put money in the tip jar. And we set rules that based on how late it is it surges. Does this have anything written on the dollar? Okay. So I'd like for it to be more than $1. We're at prime time, but we'll start with $1. And so it's been put in the jar for you. So you now may proceed.
Thank you very much.
I wouldn't do that again because that's probably the only dollar he has.
Thank you, Mr. Chairman. Like I say, this is a sort of a way to explain it would be an extension of our Good Samaritan Act. So often accidents or problems occur in a hospital with a negative outcome, and they don't rise to the attention of a death or a big major event, but the patient is unhappy maybe in knowing what goes on, whether that it really was a mistake of the hospital or the doctor or not, and it may cost them something. And so this would allow for a means of them being able to come together. The hospital could offer candor, and we encourage in some big bold print for them to have an attorney, and they would agree to enter into agreement where everybody could be honest, and they would have access to the hospital records, and they could talk it out. They could look to see and if they really are the hospital or the doctors at fault or they're not, and then come to some kind of agreement if there need to be a way for them to be compensated or to be made whole again. There's a time limit. It does not go out as long. It's basically a 2-year time limit, and it's not like the big lawsuits that sometimes run 5 or 6 years before they are settled. And the main thing, this is for patients because it gives them a chance, and for the physician or the hospital, to learn from their mistakes and to have some closure to an event. It is just exactly like it was when it passed out of this committee and was ready on a vote on the floor, and it just ran out of time last year before it was called up for a vote. Is that, and
Thank you, Madam Chair. The challenge is going to be, we now have the largest committee in the entire state Senate up here. We're running out of chairs,
think
and we
you
don't
do.
know.
thank you.
Now, Sessler
Thank
is the usual suspect.
Ah.
For the committee members, we don't have enough folders. And so if you can please share with your neighbor if you don't have a folder.
And I will say, this is an agreement between the doctors, the hospitals, the insurance people, and
The trial lawyer.
And the trial lawyer. Well, you had us until the end there.
have you noticed that the Capitol, the dome sits a little off? And that's because when we managed to get an agreement with all those people, it moved a little bit.
Let's see if we have any questions in the committee. Is it Senator Parent?
No, I don't have questions.
Do we have any questions from the committee? If not, what's the pleasure of the committee? We have one thing before that. Mr. Walker?
Thank you, Mr. Chairman. I would point out line 335, we have an effective date from last year.
We have a what?
The effective date shows
Oh.
2023.
All right. Point of order from Senator Parent.
Thank you, Mr. Chairman. I see we have like 4 maybe senators not on this committee who are with us that I've never seen in Judiciary before. I see that none of them are Democrats. I'm just curious, can you please share the ex officio letters with me?
Yeah, they're maintained by the Secretary of Senate, but I did request copies. And so, do we have copies of it?
Yeah, I never have seen this before, as a matter of fact, just for everyone in the audience.
So we have the original letters. I can't give the copies, but
I'll take a photo,
the originals
give
are
them back to
available
you.
for inspection.
Yes,
if
thank
you would like.
I'll inspect them and hand them back.
We'll pass them down. Don't destroy them. It's the only
I
evidence
won't.
I have.
Right in my pocket.
All right.
Could we just,
What's the pleasure of the committee on this bill? Motion to pass from Senator Setzler, second from Senator Hatchett. Does someone want to propose the amendment to change 23 to 24 on line 335? So moved, Senator Hatchett. Do we have a second? Second for Senator Bearden. All those in favor of the amendment, please say aye. It is unanimous. Going back to the underlying bill, motion to pass now as amended. All those in favor, please raise your hand. If you're in favor of the motion to pass House Bill 470, please raise your hand. It is unanimous, and this is being carried by Dr. Watson.
this would be fun, sir.
Is that right?
Yes,
Okay.
sir.
Thank you, Chairwoman Cooper.
Thank you, members of the committee, and thank you letting me go sort of early on so I can go home and put my cold to bed
That's all right.
and not infect anybody.
All right, give us just 1 second as we try to get organized. Yes. All right, let's go back to the top of the agenda. House Bill 505 is actually Chairman Chokas, and I believe Chairman Hatchett might also be speaking on that, but you can stay in your seat. Come on up. We're working off a committee substitute, which is LC 570128S. I believe we heard your bill last year, but it has changed. Your bill is section 1, is that, section 1 and section 2, is that right?
I don't have that LC in hand, but I do have the substitute for my part of this
Okay,
legislation.
if you can please go over that for us.
Yes, sir. Basically, what this does is it changes the offense of riot from a misdemeanor to a felony. And what we've done from last year, the changes are that the offense of riot, when he or she engages in a public disturbance involving an assemblage of 10 or more persons by tumultuous and violent conduct and results in grave danger to persons or actual damage to property or theft that exceeds $5,000. And then that triggers it to become from a misdemeanor to a felony, sir. And with the felony, upon conviction shall be punishable by not less than 1 year and not more than 10 years, and so forth. And I'll be happy to answer any questions.
All right, before we do that, let's have Leader Hatchett, if you will go over the rest of the bill for us, and we'll take questions on all parts. What's your mic number? Mic number 13. All right, the floor is yours.
Excuse me. So this bill also added back the language that we passed out of this committee unanimously earlier in the session, but it just didn't make it over, dealing with the material or financial support of a foreign terrorist group. So we included that in there. And then working with some members on both sides of the aisle, we've added that if you are fleeing from a riot and you're in basically fear of your life and you injure person or property, that you have an affirmative defense to a criminal charge against you. And then the same for you have immunity if you hit somebody and they're rioting and they're charged with rioting, they can't then sue you. So I'm happy to answer any questions.
All right, from the committee, there are people that want to speak on the bill. Any questions for either of the authors? All right, we will go to. We do have a question. Senator Setzler.
Thank you, Mr. Chairman.
Mic is still on.
I'm going to, just to the author, I understand what you're doing, I think, and I appreciate the $5,000 of damage as the threshold. Grave danger to persons. I think if the underlying act is a felony towards people, then this collective violence being a riot can be its separate felony. I think if we have misdemeanor acts of violence directed at people, that then because there's 10 people doing it becomes a felony, I think is an issue. That's where in my thinking, I'm contemplating how we address that. To me, I'm more comfortable if there's an underlying felony act of violence that's done in this context, it can be a separate felony.
Correct.
I'm just concerned as it's drafted, I just want to make sure we're not having misdemeanor acts of violence that by being done by a big group gives rise to now a felony.
Well, to answer your question, the offense of riot will remain a misdemeanor with 10 or less or $5,000 or less.
Right, but if the act of violence was shoving people, right, which would be a misdemeanor battery, right, shoving somebody. But if it never rose above shoving people, if you're throwing Molotov cocktails that fire, you're smashing people over the head with bottles and glass, that gets into kind of ag assault. As we act on this, I think there needs to be a felony level of violence in this action to have its own separate felony. That's just my concern, Mr. Chairman. Just raise that.
And I'll be happy to defer to legal counsel on that.
Okay. That's all I got, Mr. Chairman.
All right. Any other questions from the committee at this time? Senator Jones.
Mr. Chair, just looking at lines, page 2, lines 34 through 37. So it seems like we have actually two defendants here. And because the victim, if he's convicted, he's actually a defendant, because he can only be convicted if he's a defendant. So the victim in this line, 35, is actually a defendant. And then we have a defendant who's trying to establish an affirmative defense. And we say that the reasonable belief of the affirmative defense is established if the victim, who's a defendant, pleads guilty or is found guilty. Doesn't that put the prosecution in the middle of this kind of, if they find one person guilty, another person gets the defense? Have you kind of wrestled with that at all?
Well,
Senator Hatchett.
Because that was the language I've worked with, and we've talked about this, Senator Jones, and I think the issue that I have, and I understand your concern, but it's and you said it's on line 34, is that right?
Yes.
I think it's just because if someone is found guilty, there shall be an affirmative defense. If they're not found guilty and they're just charged, there may be an affirmative defense. I think there's that discrepancy there in the two different, the may and the shall. I just don't think prosecutors are going to misuse this.
Right. And I don't think it would be misuse. I just think it puts them in a situation to where they're both defendants. The victim, the only way the victim can be convicted is because he's a defendant, even though we're calling him or her a victim. The other person is obviously a defendant because they're trying to get an affirmative defense. And one defense attorney is saying, if I represent the quote-unquote victim who is a defendant, if he or she pleads guilty, this other person now has an affirmative defense to the case. This defendant here, his attorney is saying, I want you to go get a guilty plea on this guy so I can actually get an affirmative defense. Even though it doesn't say shall, it creates, the affirmative defense is created by someone pleading guilty or being found guilty. But even though we're using terms like victim, they're both defendants. The victim can only be convicted if he's a defendant. They're both defendants.
And just, Mr. Chairman, if I may, I'm happy to work on some language if we get this passed and maybe do a joint floor debate or a floor amendment that we both agree on, because I know we got a lot to get through tonight.
All right, let's go to the public testimony. If you want to step aside, we have a few people who are coming up to speak on it. We'll start with James Woodall with Southern Center for Human Rights. Good evening.
Good evening, Mr. Chair. And
Good night.
Good evening, good night, good morning.
Not yet. We won't make it.
James Woodall, Southern Center for Human Rights. I rise today in opposition to this legislation. One, I want to actually begin where Senator Jones left off. Our concern is that right now, and I actually believe that Representative Chokus is incorrect, that this bill would eliminate the misdemeanor 16-1130, because on line 46 through 59, that essentially repeals the existing language. And so all we would have is a felony offense of rioting, which would involve an assemblage of 10 or more persons by tumultuous and violent conduct. And so there would be no misdemeanor provision. Secondly, I would raise that punishment that this conduct that this bill seeks to address is already defined in Georgia's code. And so I would, reference, for example, 16-521, which is ag assault, 16-724, criminal interference with government property, 16-723, criminal damage to property in second degree. All of those are contemplated already. And so what we're doing is, in my estimation, in our estimation rather, redundant. Importantly, secondly, several of these offenses are already punishable, not just as misdemeanors, but also as felonies, particularly when the offending conduct results in bodily injury or property damage above a specified value. And so we would use that to say the conduct that is being addressed here is already covered. Secondly, I would raise that the substitute language criminalizes otherwise protected activity. Excuse me, I'm actually going to go to the second part of the bill that comes out of Senate Bill 523, which we did not hear presented by the sponsor. And one, I would also add that we appreciate Senator Hatchett for the work that he's done on 523 in terms of helping the legal organizations that do provide legal representation to some of these people that are accused. But we still have issues with the existing language. Thirdly, I would raise that the bill in its totality could punish protesters for exercising their their right to free speech. And so whether you're talking about anti-riot laws or you're talking about material support, again, this chills speech regardless of if there's the affirmative defense that was just discussed at length. But we have grave concerns about the direction this puts us, whether it's in terms of democracy and the First Amendment, whether it's the redundancy of criminalizing activity that's otherwise lawful. I would raise as a point, I know this will come up again, going back to the House Bill 505 substitute that talks about the violent and tumultuous conduct under Georgia Code, all persons connected with and sharing in the common purpose of a riotous assembly are guilty of riot. And so this bill would still criminalize people, even considering the affirmative defense. This still could chill speech and discourage people from actually participating in a lawful protest and organization, with the fear that it could become violent and tumultuous at any manner. The last thing I'll say, Mr. Chairman, is that or whomever, that is not defined in terms of what would constitute a violent and tumultuous act. And so with that, I'll pause. I'm sure there'll be others who raise some other issues, but this is broad. I mean, it criminalizes otherwise protected activities. And what I'll also add, we talked a little bit about this when the bill was first heard, 523, about the linkage between federal terrorist organizations and federal terrorist activity. What we are doing now is broadening the scope of what can be constituted under state law that's
All right, we're back. I think everything except you asking to take questions should have been still live. Any questions for Mr. Woodall? You have a question from Senator Bearden, one of our newest members. Welcome to the committee.
Thank you, Mr. Chairman. Just a quick question. Where do you define a peaceful protest and a riot? What separates that? Just out of curiosity.
So, in Georgia law, a riot is currently defined as any two or more persons who shall commit an unlawful act of violence or any other act in a violent and tumultuous manner. And so there are two distinctions here. One, the violent act, or you commit an act that is not necessarily unlawful, but you commit said act in a violent and tumultuous manner. And what that has been constituted as, you could literally just be using profanity and screaming at the top of your lungs. That can be constituted as a violent and tumultuous act. And so what we are doing is essentially codifying the ambiguity of what, to your point, what is a riot. And right now it's a misdemeanor. And as we elevate that to a felony, we are now essentially allowing for there to be prosecution of people who are simply screaming at the top of their lungs at a protest.
I guess I was just trying to figure out exactly how this is chill free speech.
That's a great question. Because if I, as an ordinary citizen in the state of Georgia, want to attend a protest or a rally or something, and this bill were to become law, arguably, it could be prosecuted if someone uses profanity in a loud manner. Because what we're contemplating is not just a violent act, or an unlawful act, rather. We're also contemplating actions that are lawful, but just done so in a violent and tumultuous manner.
I appreciate your comments. I think we just have a little bit different opinions.
Well, it's not my opinion. That's what the Supreme Court has actually defined as a riot. So, thank you.
All right, no more questions from the committee. Thank you, Mr. Woodall.
Thank you.
Ben Lund.
Good evening, Mr. Chair. I know the hour's late, so I'll try to be brief. First, I want to thank both authors who've presented these bills today, in the sense that both HB 505 and HB 523 are remarkably in better condition than they were when they were previously before this committee. The ACLU of Georgia does still have concerns, and I just want to touch on a few things. The first thing I want to go to, and this is directly to Senator Bearden's question, again, my definition of riot is irrelevant, but the definition of the Georgia Supreme Court is relevant. And so when we look at this concept of non-criminal acts which are done in a violent and tumultuous manner, we have a case to look to that's the only case I could find of that actually analyzes that language in a vacuum with those conditions. It's Green versus State. It's from the year 1900. And analyzing it, it gave several examples, one of which is persons conducting a chivaree or serenade with bells, horns, timpans, guns, etc. are guilty of a riot. And another one, several persons marched back and forth along a highway, blowing a horn, singing songs, and hallooing, constituted a riot. And that is what, and so when we look at language, now I understand that this has been modified in some ways to aid our concerns. The coercion of a political system, or however the words, I don't have the substitute in front of me, that still gives us concern, because isn't that the point of protest, is to influence our government? I wanted to raise a couple other concerns regarding the affirmative defense language. There are already on the books justification defenses when a person's, one, if your habitation, which is your car under Georgia state law, is threatened, there are already rules on when you can assert a justification defense, and if your life is put in jeopardy, where you can assert a justification defense, and use lethal force is a special category of its own. Given that, again, it's not something that I personally condone, but when people do enter the roadway, that is such a ubiquitous and common form of activity, protest activity. Creating this special rule gives me some pretty significant pause. That's something that is so commonly employed now that it seems like what's reasonable to some, enough to assert probable cause to arrest, or in this case, assert a justification defense. I'm concerned that this would give drivers who knew about the affirmative defense a feeling of that they wouldn't have as much of a concern about just driving through a crowd of people. And because, one, both for the sanctity of human life, but also because of how important the right to protest is, that I have some pretty significant concerns about Section 1, and I believe it's Section 6, which is the civil defense. With regard to material support to terrorism, given how that kind of language has been used to go after people who are unwittingly supporting, or they are intentionally supporting organizations that later are defined as a terrorist organization by our government. We've seen examples of abuse of that in the past, and so automatically that's something that the ACLU has pretty grave concerns about. But I also question whether or not this law is actually necessary, given that Georgia has one of the most expansive party statutes in the entire country, where if anyone intentionally invades or the commission of a crime, they're just as liable as anyone else is. And that's just having a shared intent and for doing any act which is in furtherance of that. It gives you party, which it means you're just as liable as anyone else is. And so I don't actually understand why we need a material support for terrorism bill unless it's to not have the intent to actually support the terroristic act. But with that, that's my comments. I'll stand for any questions.
Any questions from the committee? All right, thank you.
Thank you very much.
And last up, Maisie Lynn Girton with Gactyl, Georgia Association.
Nothing else that I would add. It would be duplicative, so I'll wait.
Nothing else to add. It would be duplicative. Thank you, Ms. Girton. That's everyone that signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by committee substitute from Senator Hatchett. Do we have a second? Second from Senator Jones. We do have an amendment that Legislative Council has pointed out. Were you going to offer an amendment? Somebody pushed their vote. Was that you, Senator Jones? Senator Parent? Oh, Senator Setzler. Sorry. Okay. I'm going to recognize Mr. Walker.
Thank you, Mr. Chairman. If I would recommend an amendment actually on lines 22 and 23 where there's a reference or a definition for the term riot as provided for in Code Section 161130. Section 2 of the bill repeals the existing Code Section 161130 where there is a definition of the term riot. So by that repeal, you would actually lose a defined term. But I think that could be cured by making a reference to rioting. So in line 22, I would recommend that it be amended so that it reads subsection A, for purposes of this code section, comma, the term riot shall have the same meaning as provided for rioting in Code Section 161130.
Does everybody understand the proposed amendment? Does someone offer the proposed amendment? So moved by Senator Hatchett and seconded by Senator Setzler. Any discussion? All those in favor of the amendment, please raise your hand. I gotta look at you, Dr. Watson. Unanimous. All right. Any other amendments from the committee? Senator Setzler.
Yeah, Mr. Chairman, I just want to offer the author. I'm on board with the framework. I get the 10 people. I get the tumultuous and violent conduct, actual damage. I love all that. But results in grave danger. I think what we're looking for is if you have results in a violent felony to persons, and then the damage to property, you have not only the violent felony that an individual would have committed, but there's a riot, a mob that's perpetrating felonies that you get one to felony for all the participants. I mean, that's a pretty stiff pop for being one of 20 or 50 or 100 people that all are going to get caught up with this felony, this 1 to 20 felony. If there's not a felony that's been committed against an individual anywhere, it becomes a rowdy soccer crowd. I mean, I don't want, I know it's not your intention to get rowdy soccer crowds who break a gate and some fencing and it's $10,000 to fix it. I think if there's an underlying felony, a violent felony that's committed, then I think you kind of get into felony land with the group. That would be my suggestion. I would like to offer as an amendment. I wanted the author's opinion of that.
I don't think that a prosecutor would go for a riot for an unruly soccer crowd. I think they would find them, I mean, this is my opinion, I think they would use other laws to determine that, because in the definition of riot, the intention is to cause tumultuous and violent conduct. An unruly soccer crowd wouldn't, in my opinion, apply in there.
And to the chair, I mean, we have this continuum of behaviors. I've seen violent soccer crowds turn violent. The police are breaking out billy clubs and beating people. It could get quite. And there's a continuum here. I think what I'm concerned about is that people protest. They break laws in protest. I'm not suggesting that folks shouldn't go to jail for things. If you block a street, you block cars, you create havoc, there's a traffic backup, someone goes to jail for that. But what we're talking about here is what you go to prison for. And I don't think people who block streets in protests that they ought to get their butt cuffed and taken to jail for, and send you to prison for 1 to 20. That's the concern. If there's not an underlying felony in it, we've wrestled with this before. If there's not a felony somewhere in this crowd, how can you make a whole group of people subject to a 1 to 20 felony if there's no felonies in the mix that's being committed? Just because they're involved in they're involved in some kind of protest. I'm not saying the protest is okay. We tend to furrow our brows and get upset when someone does something that breaks the law. I agree with it. That's why rioting is a misdemeanor now. But to do felony rioting, and if there's nothing in that group, no predicate act in that group that is itself a felony, how can everyone be guilty of a felony?
Well, if they participated.
Right. They participate in something that was not, there was no felony among the bunch. How does the whole bunch get a felony? That's my concern. So I understand what you're doing. I don't have an issue with there being this felony umbrella over a group of people that are doing violent things, one of which or two of which or three of which are a felony act of violence. I agree with that. But the words on the page here don't require that. The words on the page here say that you can have a misdemeanor act of violence, but because you're participating in a group of people, I might not have done anything, but because the senator from the 30th, there's more than 10 people in this dais, the senator on the 30th hypothetically had a misdemeanor act of violence because we damage $10,000 worth of damage to property, and there was a misdemeanor that was conducted that put someone in danger, was deemed to put someone in danger. We're all now felons. That's the concern. I mean, to me, what I hear you trying to do is if there's an underlying felony, then everybody can be subject to it. I just don't see how if there's no underlying felony for one person, 100 people can can be subject to a felony. I'm trying to help you here. Maybe I'm not
I think
explaining
the
it well.
answer to it is you have the defense on lines 57 through 59 of someone that does withdraw or abandon at the time something turns into a riot. You also have the actions that would constitute a felony under this, which are lines 49 through 53. While they may not be a felony elsewhere in the code, the bill passes. My read of it is if you do these offenses with 10 or more people in a tumultuous, if I can say that word right now, and with violent conduct, then it would now be a felony.
Right, but does the chair agree that it doesn't require a felony anywhere in this to trigger that Section B felony?
Yeah, I think that is the felony. Is that right?
I can tell you the Senate depends on us to get this right in this room. I just don't think, this has come before the legislature before. We never let something pass out as a felony riot that didn't have a felony act in it. There was a bill that the senator from the 46th brought several years ago that raised this issue, and in the deliberation process that kind of stepped this down. There were other things. There were terrorist acts that were seriously dealt with, but this issue of misdemeanor violence creating a felony because it's done collectively,
And the damages being over for $5,000.
Here's the posture we're in. We have a motion to pass. It's been seconded. We had one amendment offered, and I think we're at this. I think you're the phase of arguing on the bill itself. Do you have any amendments that you want to offer at this time?
Could I ask one question to the author of the other language that's worked this? I mean, the amendment I'm contemplating, Mr. Chairman, I don't want to do it in an aggressive or unwelcome manner, but I'm contemplating the word grave danger to persons be replaced to results in a violent felony act to persons or directed to persons, results in a violent felony act to persons.
Would you do that on lines 49 and line 52? Or just line 49?
49 and 52, Mr. Chairman.
Would you leave line 51 as it is?
Well, again, Mr. Chairman, I've got concerns once again. To the chair's point.
That's not going to solve your concerns, my point.
Right, right. My concern is to the author, obstructs the performance of a government function. If the riot prohibits the trash truck from moving, or the riot prohibits, public access to City Hall because there's people trying to get into a meeting. I'm not saying that it shouldn't be against the law. It should be against the law to prohibit people from getting in City Hall. But if a riot, this act prohibits people from getting into City Hall to a meeting, right now it's a misdemeanor. What this would say is if you create a disturbance that obstructs a city council meeting, it's a felony. I mean, do we really want felony obstruction to trash trucks, I mean, in an ambulance? I mean, it worries me that you're blocking an ambulance, but are we in felony land because we're involved in that kind of thing? I just don't, Mr. Chairman, I want to support this effort. I just don't feel comfortable with the language. And I don't know that that's the intention of the author.
All right, I think at this point, we're at the stage of offering an amendment, or we're going to vote on the bill. Is there an amendment you want to offer, or do you want to just move to vote on the bill?
Would that be a friendly amendment to the author?
The proposal of adding results in a violent felony act directed to, and I can't read my last where I wrote, what's the last part, to a person?
I would say this, Mr. Chairman, I would say results in, strike grave danger on 49 and insert results in a violent felony act. On 3 results in, I'm sorry, on 52 results in a violent felony act. And then on 51, insert commits a violent felony act that.
Okay.
So in all of these, there's a violent felony act that some participant in this riot's performing that leads to obstruction of government functions and so forth. That's my amendment, Mr.
Do we have a second for the proposed amendment? A second from Senator Jones. Does the author or the Senate author have any feedback before we vote on the amendment? What's your mic number, 13?
13. I mean, once again, I'm good with the spirit of the amendment. I know the Representative Chokas has worked hard on this. I probably wouldn't support the amendment at this point, but would still be open to try to working with the minority whip and Senator Setzler to see if we can come up with some language for the floor, if this gets passed.
The amendment has been offered and seconded.
I will withdraw it, Mr. Chairman, if there's a prospect of fixing it moving forward.
Yeah.
Okay.
Let's go.
All right.
Withdraw the.
Back the underlying motion do pass by committee substitute as amended. All those in favor, please raise your hand. It is Dr. Watson, unanimous. All right. Is it being carried by Senator Hatchett after all this? Senator
Absolutely.
Hatchett. All right. Thank you.
Thank you, Mr. Chairman.
Thank you.
Members of the committee.
All right. Next bill on the agenda, House Bill 1075. Representative Hilton, come on up. Working off the version that passed the House, LC 520443S. If you can tell us what this does. Floor is yours.
Thank you, Mr. Chairman, members of the entire Senate.
Any questions for the author?
Yeah. House Bill 1075 passed unanimously out of House Judy and passed unanimously.
That doesn't mean anything to us, so you say something else.
Okay.
He's telling more jokes, Mr.
Right. Yeah, more jokes.
House Bill 1075 applies to state agencies and allows them to accept notarial acts outside of the state of Georgia as long as they are approved within the state that they are done. Just by note, there's 44 different states notarized in different ways. So again, this only applies to state agencies. We did a very specific carve out. You'll see on lines 34 to 36 to exclude anything having to do with real estate transactions. So
You did such a good job on this. Are you an attorney yourself?
I'm sorry, Mr. Chairman, I don't have any money on me.
Okay, that's fair. I don't believe that.
I can Venmo the tip jar.
We do take Venmo.
Okay.
Any questions for the author? Mr. Clayton, you can only screw it up if you start talking. You want to talk about it?
I'd like to waive, Mr.
All right,
Chairman.
thank you. What's the pleasure of the committee? Motion do pass from Senator Setzler. Is there a second? Second. Welcome, Senator Walker. Second from Senator Walker. All those in favor of the motion, please raise your hand. Where are you, Dr. Watts? He's for it. All right. It is unanimous.
Thank you.
Is Senator Walker carrying it? Or?
Senator Setzler.
Senator Setzler.
Yeah.
All right.
Thank you.
Thank you. All right. Next bill on the agenda, House Bill 1371. And I don't believe we're going to have Whit Burchett here, so I am going to present this briefly. I'm working off of LC 442839S. I have not been engaged in the discussions over this issue over at least the last year, but there's been an effort I think a lot of people in the room have been a part of in trying to address premises liability in our state. There was the whip in the House, Representative Burchett carried this bill in the House. There's been some changes offered since then to try to go a little bit further than the House went on this, trying to figure out how to reach a balance. I think what has happened is that attempt has fallen apart. I think we probably have a bill that nobody really likes, which probably means it probably ought to pass. And it could, in my opinion, it could move the needle on this issue, even if it's not something everybody wants at this time. What the bill does in Section 1, you'll see it deals with plaintiffs that are trespassers or loitering on property. It says that they cannot bring claims for premises liability if you are a trespasser or you're loitering on property. It also says that you cannot bring a claim if you enter property for the purpose of committing a felony or for the purpose of shoplifting. There's an exception in that clause. You see lines 18 and 19 for victims of human trafficking. I think that kind of speaks for itself. Lines 20 through 24 deal with the issue of foreseeability. And this is an attempt, from my understanding of the intent of this, was to codify the case law and to confirm that while high crime areas itself can be considered as a factor for foreseeability, that in itself is not enough to establish a duty to keep the premises safe. And finally, under Section 2, this deals with apportionment, and this confirms, I believe this is a true shift, not even in the case law at this time, that a jury shall consider apportionment and consider the amount that a person committing a crime should have to account civilly for that offense as well. There's probably, I don't see the sign-up sheet, maybe a little interest in speaking on the bill, but I will now open it up to, let me first, before I do that, I guess as author sitting here, any questions for me on this bill? Senator Dolezal?
Thank you, Chairman. Thank you for presenting the bill. Can you clarify for me, I guess it's Section A here, does this references the code section for invitees, is that correct?
When you say it references the code section
The
for invitees.
5131. So in other words, these bills that I've dealt before, we've tried to deal with invitees, licensees, and trespassers.
That generally deals with premises liability claim in itself, is my understanding. You have to pull the code section up, which we're about to do.
I did pull the code section up, and it references the implied invitation or induces or leads others to come upon the premises for any lawful purpose, which I think in the colloquial language would be an invitee. And so I'm curious if that's correct. And I see that code section referenced multiple times in other places. What, if anything, does this bill do relative to licensees or trespassers?
So the code section that you reference is a general provision dealing with the obligation of an owner to keep a property safe for invitees. And so I guess in a legal sense, it's a premises liability generally clause. And so your question was what was the question?
Well, if you read down to 3.2 and then 3.3, you'll see licensees and trespassers. And so I'm just noticing the omission, or I should say really more so the exclusivity of this bill focusing on 5131, which is invitees. I'm just trying to clarify, from my understanding, does this bill focus on invitees, and is it silent on trespassers and licensees?
So it is dealing with those that would have a claim for premises liability generally. And what the bill does is a plaintiff that is injured and would have a claim for premises liability if they are a trespasser or they are basically approaching, as it says here, the premises without express or implied invitation, then they would not be able to bring a claim. So it does exclude those claims. And second, it also those that are going onto someone's property, whether they're invited or not, with the purpose of committing a felony or shoplifting, would also not be able to bring a claim.
So how, referencing 5131, how does Section 1 there apply, which is diametrically opposed to the definition in 5131? How does someone who is invited on a property approach without an expressed or implied invitation?
So it's a bar to a claim. It would be a defense that could be raised by a property owner that says, even though, let's just use a shop for example, even though I'm open to the public, this is someone that trespassed or came to my property to commit a felony, and that was the intent, or to shoplift. It would actually protect the property owner in our state from being sued by someone who ends up getting hurt while they're on your property by somebody else, but they came there with the intent to commit one of these crimes, or they came there not invited in any way at all.
If they came there not invited any way at all, that would be 5133, which is the preceding code section we're tacking this on the end of. That's kind of the heart of my question. I'll let others join in, and maybe we can discuss that.
No, 5133 deals with a duty that you generally owe to someone on your premises. This would be additional language with this new code section that would bar certain claims for premises liability.
All right, so 5132 is licensee. (5133) landowner possessor of land owes no duty of care to trespasser. So 5133 is specific to trespassers.
5133 is not what you just said it was.
I'll read it to you.
It's a duty of care that's owed the trespassers in general.
Section B of that code section, lawful possessor of land owes no duty of care to a trespasser except to refrain from causing willful or wanton injury.
That's correct, generally with a trespasser. But this goes beyond that. This actually goes beyond someone that's entering premises without express or implied invitation. It's a little bit broader than just a trespasser. I use the word trespasser, but it's by legal definition, trespasser is a different term than what I use. It's just broader. Anybody that came on your property without any implied or express permission would now be barred from bringing a claim under these circumstances.
Okay, I'm just curious why the reference then to the first code section I mentioned, and maybe I missed your answer and I apologize.
My understanding, and others can correct me because I've been involved in this for a few hours versus a year, but my understanding is 51.3.1 is generally the paragraph that allows for premises liability cases in general, and that's why you have a reference back to that. But what this bill does, and this part I believe is consistent with what the House passed, would actually bar these claims in these circumstances here.
Okay, I'd be happy to read 51.3.1 if that'd be helpful. Where an owner or occupier of land, by expressed or implied invitation, induces or leads others to come upon the premises for any lawful purpose, he is liable in damages to such a person. So that speaks specifically to the invitation, right?
Sure.
The next section speaks to, because this is all about duty of care.
Mm-hmm.
And what duty of care does the landowner have in these third-party negligent or security, these third-party security negligent security cases. The second one speaks to a different duty of care that applies to licensees. And then lastly, the third piece that I referenced speaks to the duty of care that is owed to a trespasser. So the bill that we passed out of Chairman Walker's committee addressed all three of those qualifications of person who's on a piece of land, the duty of care the landowner had to them. So maybe a better way of asking my question is, does this bill, as you understand it, speak to separate duties of care for those three different types of individuals?
No, my understanding of the bill is just as I described it. What this bill would do is protect a property owner from someone bringing a claim against them for injuries they have on that property when they come on that property without express or implied permission, when they come on your property with the intent to commit a felony, or to come on your property with the intent to shoplift, with the only exception being the human trafficking exception. So those parts of the bill, now, is there more you could do in these code sections? I'm sure, but that's what this bill does. This bill does provide those protections that are currently not provided by law.
I believe.
Hold on, let me get your mic back on.
I believe it does everything that you just said, but only for invitees. And that's, I think, the reason why 51.3.1 is repeatedly referenced in here, but the other two sections I spoke to you of are absent.
It does reference back to 51.3-1, but keep in mind, invitee is not someone you just say, come to my property. It's also a store, a small business that's opened, and being open to the public obviously invites people to your property. And that's, again, in the discussion on this bill, is there things you could do under Georgia law? Sure. But what this bill will do is protect those business owners from these types of claims. Senator Kennedy.
Thank you, Mr. Chairman. I too have the same questions that Chairman Dolezal has, and I read it the same way he does. And I think two very intelligent folks reading this are coming away with two different interpretations. I think the only way that we can read it the way you're saying it's to be read is if you added that an owner or occupier of land shall not be liable under Code Section 51-3-1 or 2 or 3. Otherwise, there's an internal inconsistency because, as was pointed out, if you're traveling under 51.3.1, which applies only to invitees, it makes lines 13 and 14 nonsensical because you're talking about invitees and then you transition to where the plaintiff came upon the land without expressed or implied invitation. If they are that, they are not an invitee. If the intent of this is to apply this protection to all three classes of visitor to a land, to a piece of property, if that's what the intent is, then you would have to include all three code sections.
Well, again, the intent is to address the situation I provided, which is you have a business owner that is open to the public, has someone come on their property with the intent to commit a felony or intent to steal from them, or they're coming onto their property after being expressly told not to come on their property. Those individuals under current Georgia law would have the ability to sue that property owner for crimes that occur. They go on your property, then they get shot by someone while they're there. They're injured somehow. They trip and fall while they're there. Whatever the injury is, this bill would protect against those types of claims and provide those protections for our business owners where, while again, is there more you could do in going to other code sections? Maybe. But this bill we have, what it would do is protect those business owners in those situations.
I respectfully disagree. It can't. And the reason it can't is the very beginning is an owner or occupier of land shall not be liable under Code Section 51.3.1.
Sure.
Which is only invitees. Everything else follows that.
Right. And so
that sets up the broadest parameters.
An invitee that goes onto property to commit a crime under this bill, again, would not be able to bring a claim for third-party liability.
What about a trespasser?
No, a trespasser could not either. But again, trespasser is a defined term, but this is a little bit broader, and it would cover anyone that approaches without express or implied invitation. That's what the words of the bill are.
I understand the words of the bill, but they're internally inconsistent. They are. And when you limit this applicability only to invitees, then the owner doesn't get the protection if a different class of person comes on the property.
Yeah.
And if the intent is to do what you're describing, then we should amend it to include 3-2 and 3-3 so that all three of those classes of someone coming on the property under any of those three, which is what you're describing, the owner gets the protection. Right now, it will be argued by counsel that for the trespasser who came on and did this, there is no protection for the property owner because it only applies to invitees.
I just disagree, but that's what lawyers do, I guess.
Okay, all right. Can I move on to another question since you're presenting? So Section 2 on lines 15 and 16.
Before we do that, on that same section, is
Yeah.
that your question, Senator Hatchett? We'll go section by section.
I understand what the Senator Dolezal and Senator Kennedy, or Pro Tem Kennedy are saying. 51.3.3 deals with trespassers, and it says it deals with willful or wanton conduct. 51-2 also willful and wanton for licensees, but I mean, I don't think it would do anything. Honestly, I think I kind of side with the chairman, but I'm okay with adding that language in there too. I'd support that.
Support adding 50.
Yeah, but I think you'd have to do it on line 11 and on line 20. You'd have to do 51.3.1, 51-3-2, and 51-3-3 on line 11 and line 20. So that captures their concerns.
So 51-3-2 deals with licensees.
Correct.
And the trespasser part.
You don't owe a duty to a trespasser except.
Right.
Yeah.
All right, we'll go back to that. Let's go back, Senator Kennedy, you're going to another section.
Yeah. Thank you, Mr. Chairman. Looking at lines 15 and 16, so if we're talking about an owner of land should not be liable, set aside what class of person comes on, right? Or the plaintiff came on the land without express or implied invitation. So since we got the conjunctive or, we can disregard one. So we go back to the owner of the land shall not be liable to a plaintiff for injuries incurred by the plaintiff from third-party criminal activity. Skip down to 15, where the plaintiff came upon the owner or occupier's premises or approaches for the purpose of committing a crime punishable by more than 1 year imprisonment. So my question is, what is the thinking behind why we limit it to conduct that is in essence a felony?
Yeah.
Because what I understand then is, so if I'm the owner of land and the plaintiff comes onto my private property as an invitee under this construction for the purpose of committing a misdemeanor, then the plaintiff can recover from the owner.
That's the current
But if
law,
the
I
same
believe.
person
Right.
came on to commit a felony, they can't. Either way, you've got someone coming on private property for the purpose of conducting criminal activity.
Sure.
That doesn't seem
Yeah,
like
that's
good
a
policy
broader,
to me.
that's a policy decision for us to make. All I know is in the current law says either way you can bring a claim. What this bill does is it deals with felonies and deals with shoplifting. And it goes back to the point of if you want to present something that's more expansive, then that's something anybody can do. But this bill does at least cover those offenses, the felonies and shoplifting, which current law does not, as far as I understand it, protect against.
Where's the shoplifting reference?
That is line 17, chapter 8 of Title 16.
Okay. That's shoplifting?
That is my understanding. We'll pull it again. That's why I
Okay.
sit next to Patrick.
All right, thank you. So,
Offensing involved, yeah, I use the word, again, I'm using certain terms like shoplifting, trespassing, but it's any offenses involving theft that are included in 16.8-1 through 16.8-106. So it'd be beyond shoplifting. There's
Okay.
a long line of offenses that are included in that.
what
Is
would
that
be
on, are you still on that topic? Is it,
I am,
okay, let's finish,
yes.
let him finish,
Yeah.
then we'll go.
I'm curious what the policy reasons are behind why we would limit the type of criminal, anticipated criminal conduct by the criminal to give the owner protection.
Well, the question would be, do you?
Why not any criminal conduct? in other
Well,
words,
that's
is what I'm saying.
again, current law doesn't say that at all. I'm sure people that do these cases could give examples. The question is going to be with this bill, if it goes as it is, do you want to make sure that those that are going with the intent to commit a felony and a theft crime cannot bring these claims, or do we want to allow those claims to move forward as the law currently allows? Senator Setzler.
Chairman, I'll try to answer the senator from the 18th. And this is, I mean, to Senator Kennedy,
You're still, you want it off?
when I read this, I thought it was kind of creative the way it's felony or theft, which is going to commit a property crime. If you were, for example, if someone was injured and they found out that they had misdemeanor possession of marijuana, there was pot in their car. Well, you could say, well, they came onto the property to buy chewing gum and some Doritos and a Mountain Dew, but because they've got pot in their car, they came to commit a crime. Therefore, they don't have the ability to bring a case. Or if they're found to be involved in if it's a prostitute, for example, and she's part of some, happened to be in a convenience store and something happened to her. Now you could argue that she's involved in an act of prostitution. Does that make her not able to claim to get recovery? Well, the act of having pot in your car, which I'm not diminishing, but it's not related to perhaps the being in the convenience store or the place of business, and that by virtue of you being there with that, does that keep you from being able to get recovery? I don't know that those two are linked. I think a felony keeps you from being linked. A theft or something that's in furtherance of a theft keeps you from getting recovery. That seems appropriate and germane, but I don't know that if you're part of some other misdemeanor scheme that's going on that's not related, I think that's what's getting at me. To answer your question, that's how I read it. But
Senator Hatchett.
Yeah, and I think obviously there's a plethora of cases that or hypotheticals that we could come up with, and I think this language in particular is appropriate to protect an underage college girl that walks into a bar and gets raped in Athens, who is drinking underage, which is a misdemeanor. I mean, I've got daughters. I think it's dangerous to open it up to all crimes because you never know. I think this language is pretty appropriate there.
Senator Kennedy, do you have other parts you want to address?
Thank you, Mr. Chairman. Looking at lines 21, it says, under this code section, again, limited by 51-3-1, for injuries arising from third-party criminal activity, whether the premises or approaches are located in a high-crime area. Is that defined anywhere, either in associated context or other statutes? I don't see it here.
My understanding is that has been fleshed out with case law. That's my understanding of that. But it's not and I'll be corrected if I'm wrong, I don't believe it's a defined term under our statutory law, but I believe it has been spelled out in case law. And again, this goes to foreseeability. This is the idea that, do you have a duty, right, to protect someone? What is it foreseeable that the criminal activity is going to happen that we're talking about here would actually occur? And I know there's been arguments in case law that I've read where someone says, well, it's a high crime area. Of course it's foreseeable. And you could argue that, you could paint that picture anywhere in the state if you wanted, right? Your definition of what high crime is. And what this confirms is, while that can be a basis for foreseeability, that's not enough in itself. You have to show more than just a high crime area to establish, to get to that foreseeability, which goes to the duty.
Understood. I think, though, that kind of reveals the core question that I have about high crime area, as well as the question on line 30, which I'll go to in a minute. But it seems to me that the nature of crime is fluid. It's typically mobile. It depends on who's in a particular place at a particular time. And I think that creates some real challenges to fairness to property owners, especially if your property isn't the subject of criminal activity, but you're close to property that would meet that definition. What do we do about those people that find themselves in a high crime area, but they've done what they can?
I completely agree, and those are the people that this would help, because it's saying the factor in a high crime area in itself is not enough. While that can be a factor, as we know, that can be a factor, it takes more than that. And the fact that if you did take certain actions to protect against crime, then that would obviously be part of the claim as well, part of your defense. But the bigger part you're looking at here is whether, under foreseeability, do you get the duty that is owed to someone based on just there being high crime, and this bill confirms that's not the case.
Well, I don't think it's just high crime, and I guess the question becomes, from a policy standpoint, do we want to inject that as something for consideration in the way that this does? And I guess that's a policy decision we've all got to make.
Yeah, give you another clause you could add to the bill, sure.
Well, I think without defining high crime area and the challenges that has, and like we talked about, where you have adjacent property that is not a high crime area, or someone deems it is, but it's not the subject property they own, I think it creates some real difficulties. But again, policy
current law doesn't have that at all. I think you'd agree with me that current law doesn't define in the code what a high crime area is. What this will do is confirm again that someone can't just argue because there's high crime that means it was foreseeable that that would occur. Well, I think you'd agree with me this is at least a step. Now, if you want to go further, again, you have the right to file a bill and do that, or file an amendment and do that, but this does move the needle on that.
I'm not sure that it does, because does the law currently address or say that a high crime area should be deemed to be reasonably foreseeable? I don't think it does. So I think this interjects that issue where it's not in the law now.
My understanding is in our code now, it does not address the fact that the mere fact that you're in a high crime area can be used as a basis for foreseeability, and this will do that.
But under the current law, it's not precluded.
It's all in case law.
Right, okay. Which is why we've got to make good statutes.
That's right.
Right, okay. Thank you, Mr. Chairman.
Did you have anything else you wanted to address?
Not on that section. That may be it.
Other committee members, Senator Harbin?
Yes, sir.
Welcome to the committee.
Welcome. Question.
Get your mic a little closer so we can hear you.
Senator Dolezal brought up 51.3-2 and -3, and I was reading -2, and I'm trying to understand from your standpoint of why we would not include all three that are there the way it is defined. On 2, it declares that the owner or lawful possessor owes no duty of care to a trespasser except to avoid willful or wanton injury. Such actionable injuries occur when the owner allows unreasonably dangerous conditions or conceals them from the occupant. I can understand that issue, but if he was coming, why would we not use 1, 2, and 3 in that issue? I'm trying to understand that.
again, this is all I can say is this is a version that was negotiated at great lengths by everyone involved in this. Now, if we want to go further and include licensees, and I think the trespassers, I think we all agree is addressed directly in 5133. I'm not sure we want to change that duty of care of trespassers. I think seems to be pretty clear, but whether licensees should be included, that's a question for the committee. Any other questions from the committee for the current author of the bill? Senator Hodges or Senator Walker? Somebody pushed the button. Senator Walker.
Number 12. Thank you, Chairman. And I have a little bit of money, and I'm not a lawyer, but
pass this down, please.
I am an insurance agent, and I do know that
got lots of money coming out of that.
We're finding that skyrocketing premiums and harder to place business. I'm gonna give you $2.
That's good. Yeah.
I'll double what the lawyer friend to my right did. So this is a very important issue to our business community, to our economy, to our citizens. These costs and insurance premiums do get passed on to the consumer. So because I'm here at almost 10 o'clock, I'm going to ask a few questions, even though I'm brand new. What about this whole 20 to 24 that Senator Kennedy was just talking about in the high crime area and the foreseeable? On line 24, it says, or 23 and 24, sufficient to establish a duty to keep the premises and approaches safe from criminal activity. Doesn't a property owner already have a duty to do that?
Yes, and again, this goes to qualify that duty and to limit that duty. And what it's saying is the mere fact that Larry Walker's insurance company is deemed to be in a high crime area would not be enough to meet that duty. It would take more than just that, though it can be a consideration, but that would not be in itself enough. That's what it appears to me the intent is.
Would there be any willingness to maybe just strike that whole part that interjects the high crime area that's not defined and just seems like it creates
I mean, honestly,
some
just
ambiguity and some confusion. I mean, if the property owner already has a duty to keep their premises and approaches safe from criminal activity, I don't see where it's...
You would not have anything in the law and code that says that high crime area in itself is not enough. But if you strike, you would fall back to... You strike all this, you're back to where we sit today. So
okay, so that's one question. And then my other question is on the apportionment percentage or some percentage on line 32.
Yeah.
Is there any way to give more guidance to the court or the judge on how much apportionment?
That, I believe, is a jury question by law. My understanding, somebody correct me that knows better than me, current law doesn't say this at all. This is, I think, you could argue that you're codifying some case law when it comes to 20 through 24 and maybe clarifying some case law. But my understanding is current law does not mandate, as this does, that the person that caused the injuries be apportioned part of the fault. And so it is a pretty big policy shift. But juries are responsible for what the apportionment is because it may vary by the case. And I think you'd ultimately, it's just now you're in my opinion world. My opinion would be that's a jury case by case, but they'd be charged when they go after hearing a case that they must now consider the apportionment of the damages that's owed to the person that committed the crime.
So it wouldn't be probably legal or appropriate to put at least 50% or anything like that?
Probably not.
Okay. Thank you.
Any other questions from the committee? There are others that want to speak on it. Senator Dolezal.
Thank you, Mr. Chairman. Let's, one last question, if you'll allow it, on your fine bill that you've worked on here. Thank you
See
for
my handwritten notes in the last hour I made.
Thank you for indulging our questions. I too have some concerns with this high crime area piece. Obviously, this has been something that's been used evidentiary in cases, and essentially by codifying this into law, and you're saying that it may be considered. We are essentially allowing evidence to be used to be used against the landowner for something that's completely outside of their control. And so, and I wonder, thinking about perhaps a real world hypothetical example of this, if we were to say that Buckhead was a high crime area and a crime happened at the St. Regis, which is not really known as a high crime place, and who has security, is the fact that Buckhead is a high crime area, are we going to use that reality to condemn the St. Regis and potentially say that they are going to be held liable for something that happened because a mile and a half away there's a consistent history of crimes at a gas station? I mean, I think
so in my opinion, that's a great example of why you would want this language, because what this says is that cannot be what you use to find foreseeability. While it can be a factor, obviously, and current law allows it to be a factor, we will codify that cannot be the basis.
Current law does not allow it to be. Current precedent allows
Right.
it. And I think that part of what we're doing here, I hope, is looking at some of the precedents that we have an issue with, and looking at the fact that the courts have said that we need to, that there is some question as to what the intent of the legislature is. I think that this is a piece that we need to really think about as to whether we do want this to be consistently entered as evidence in cases against landowners. That 3 miles down the road, you had a gas station that consistently had carjackings at it. Therefore, you need to provide these levels of security measures outside of your hotel, so that there's not an assault case, or that in an assault case that there is something that could get pulled in. And I'll leave that at that. Secondly, the question of apportionment is important. I think that we know in the CVS case there was 0% fault that was placed on the person who actually committed the crime.
Right.
The Six Flags case, there was 8% fault placed by the jury on the person who actually committed the crime. 92% placed on the landowner. And while I think we can disagree on the nuances of these things, I think that reasonable people would agree that the person that commits the crime bears the majority of the fault. And so the sum here, the word sum on line 32, gives me concern that we are codifying the ability for people to use 1%, 2%, 3%, 12% to meet that standard, and then we're really removing the ability for those verdicts to be set aside. And so I wonder, and I'm not the lawyer, I would refer to the lawyers here, but to me, some opens.
No, I think it's up. The last person.
Did I say I'm not a lawyer?
We have to
That's,
do.
So I know $2 now.
We've been doubling. You're at $4 now.
Larry, I gave you $5 a couple weeks ago to get a haircut, and you never got it. So can you guys pass that down to Larry?
You owe $4 if you want your mic to stay on.
Send me your Venmo. I'll take care of you.
Okay.
Keep the $5 and get the haircut this weekend. We'll check on you on Monday.
He only has $100 bills. I think.
That's true. So I'm wondering if we replace some with reasonable, or if there's a more technical term for those people who are a lawyer. See, I don't owe any money for that, right? For those that are a lawyer.
That was okay. Yeah.
Okay.
Well, that's what it says. Look, here's the thing.
So the some percent, would you agree, though, that some percentage would codify into law that juries can apply 1% fault to the person who shoots somebody in the head and apply 99% fault to a landowner? And we would be handing out verdicts with those percentages codified in our code. And if so, I think we would probably all agree that's
I will
probably
say again, with all due respect, there's been attempts, maybe by you even, to pass other versions of this that have not been successful. Could you go further? Yes. If you don't pass this, that's zero. That's current law. The person responsible is not, the jury is not obligated to do any percentage of fault. What this says is they must consider fault. Shall, in better words, shall apportion some percentage of fault. Could it be 50%? Could it be 1%? this requires them to do it. Current law does not. So could you do more? Sure. You got to pass the bill. And that's kind of where we sit here. Can we move the needle on this? Or should we just continue to do nothing because we can't agree on where the needle should be? And that's where, in my opinion, this is giving the votes in the House and Senate. This is a way to move the needle on this. And down the road, if you want to do something to try to go further and get it passed, you have a chance to do that.
Chairman, isn't this bill substantially different?
I'm turning your mic on.
Is this bill, how much of this bill here is what actually passed the House?
I don't believe I think we're going to pull it up. I believe this section is very close to what passed the House.
Okay.
Well, we can take one thing at a time. Yeah. The House did very little on this. They did one section, right? Yeah. They did include this part, lines 18 through 22. No, I'm wrong. That is lines 20 through 24. This part was not in the House version at all, I don't believe. Someone can correct me if I'm right. Yeah, this was not the House portion at all. So the House didn't even address this.
Okay.
So I'd hope we at least can move the needle more than the House did.
Well, my concern is that in an attempt to move the needle, if we make it worse,
Yeah.
that I think we would all agree that's problematic
I would
as well.
agree.
So
The question is some percentage of fault or
a
zero?
reasonable.
Again, if you want to do nothing and complicate it, that's possible.
You're presenting me with a binary choice I don't think exists. What I'm saying is that we could actually make this better, send this over to the House, and they would find this to be agreeable as well.
I'll say I know you're new to the committee as others, but we take amendments. So if you want to offer an amendment
Absolutely.
at the appropriate time, we'll have a right to offer it.
Would you be open to an amendment that remove this bill and replace it with the bill that passed Chairman Walker's committee?
I will be as patient as I can with amendments.
Send me your Venmo.
Somebody else pushed their button. Senator Hodges.
I've got a simple sidebar question, I guess. If I'm a property owner, say I own a convenience store, and somebody comes in to shoplift, and somebody sees them shoplifting, and they punch out the person who saw them, I, as the owner, am now liable.
You want to hear a lawyer answer? You could be.
Under this?
Under this, you would have a defense that you wouldn't currently have codified under Georgia law.
Under this, I would have a defense that I don't have now.
That's right.
Okay, that's the answer to my question. I was like,
Otherwise, you'd be relying upon case law to make your defense. Any other questions before we let people who probably know more about this than me speak? That was an invitation to move on, Ken. Senator Kennedy.
I'll just, you may not want to answer this, maybe we can come back to it, but if you could help me with this. So D1 under section 2, lines 30 through 34.
Okay, yeah.
It lays out the standard, and then it says, comma, provided that all requirements of this code section are otherwise satisfied. I don't really know what that means in the context of this section, and maybe we'll defer on that. Maybe anyone
Yeah, we'll
else can
defer. I think
address
that's
that.
generally the rules on apportionment and how a jury does apportionment, I believe.
It is, and I've read that statute, and I still don't understand what that means. I don't know if it's a qualifier that limits this or expounds on it relative to 51-12-33. I just don't know, and I thought if you had an opinion or could help,
Yeah, I
on that,
don't-
or maybe somebody else
Yeah,
could.
we can see
I
if
don't know
anybody
what
else
that
can
means.
shed light on that.
Okay, thanks.
All right, let's move on to our speakers. Skin Edge. And Skin, I can't read what you wrote. National Association.
Security companies.
Security companies.
Yes, sir. My handwriting.
Welcome. First time this year to Judiciary, I think. To this Judiciary.
I think one other time,
Okay.
Mr. Chairman, with the municipal court judges.
Oh, yeah, that very important bill, groundbreaking. We passed that today, didn't we?
Yeah, actually did. Yes, sir. Well, Mr. Chairman, members of the committee, I appreciate the opportunity to come before you and make some comments on this substitute to 1371. Senator Walker is exactly right. One of the biggest problems we are facing in this state today is the increased cost and the increased exposure liability exposure that businesses are facing because of these third-party tort actions that they're having to defend and having record judgments entered against them on. It's a huge, huge problem. It's such a problem, and it's gotten so out of hand, and I imagine Senator Walker probably knows a little bit about this as well. It's gotten so out of hand that you're seeing insurance companies either leave the state, they're refusing to provide liability coverage, or they're saying we're only going to cover up to just a certain amount, or they're raising the deductibles, all of which leave the business community and the business owners and the property owners in a very delicate situation where they have vast exposure to a verdict being rendered against them for a third-party criminal act that they did not commit. Now think about that. Is that right? Does that sound right? So it's a huge problem. Ladies and gentlemen of the committee, I say to you tonight, and I think some of this has become hopefully apparent from some of the questions, good questions have been asked already. I say to you tonight, this bill does nothing to address the problem that we have in this state. It does nothing. If anything, it moves the needle backwards, not forwards. And I can assure you, if we thought that the needle was being moved forward in a meaningful way, I wouldn't be standing up here opposing this bill, nor would the Georgia Chamber of Commerce, nor would NFIB, nor would the insurance community, nor would the entire business community. The only people I know that are supporting this bill is GTLA and their folks. That's it. The entire business community is against this bill. We considered language. We negotiated in good faith for hours and hours and hours at the beginning of this session and could not come to an agreement with the other side. And we decided that so we couldn't, that we would step back and try to address this problem next year. And I think that time has come. We are here tonight, 3 days left in the session, at 10 o'clock or so at night, trying to deal with one of the biggest problems we got. And I'm afraid if we do that at this late hour, we're going to get it wrong. And I think every business person in this state will tell you if you adopt something like this, you've gotten it wrong. Now, let me make a couple of comments, and this is just not skin edge speaking. The Supreme Court, when they ruled on those cases, those three consolidated cases, one being the CVS case, which is the most famous, the Supreme Court realized that their hands were tied by what they thought the law was and is, but they said they called upon the legislature to take some action, but the appropriate action. And let me quote from one of the justices: to what extent, under what circumstances, proprietors, business owners should be held liable for third-party criminal acts or decisions best left to the legislature. But they are concerned, and the justice said, I am concerned about the impact these rulings have on those who reside in high-crime areas who face the harsh and mounting reality that businesses face with an increased exposure to liability because of the very area in which they have chosen to do business will cease operation or raise their prices to offset the cost of additional security measures. And I wonder how these forced business decisions will impact the residents who will lose ready access to resources they need for daily life because they are no longer available or affordable. That's the Supreme Court speaking. Ladies and gentlemen, what they're talking about, frankly, are food deserts, pharmacy deserts that you see popping up all over this country and all over this state in certain areas because businesses say we can't accept liability, the risk of liability. We can't take the risk there. And recently you've heard of some businesses right here close to the Capitol that have closed down because of this. They've shut down. And people don't have access to their services or their goods, and the businesses don't have a chance to provide services and make a profit. So this is a problem that is recognized by the business community, recognized by the Supreme Court, and again, this bill doesn't address it. Let me just take a couple of examples. Number one, on line 11, the first section, an owner or occupier of land shall not be liable. That language does not cover their employees, their directors, their security contractors, their other independent contractors they have working on the property. So what's going to happen if by some chance the owner is covered here? Then the lawyer's going to turn around and they're going to sue some employee or some security company that they've hired to protect people, or some other independent contractor for some reason. I would suggest to you that this is very narrow and it's drawn for that reason. I agree, all due respect to the chair, I agree totally with Senator Dolezal, Senator Kennedy. When you look at line 11, it references the invitee statute. It does not say anything about licensees or trespassers. And if you look at that section, then you go down to lines 13 through 16, those instances, the person is not an invitee. So this does nothing. It says you can't bring an action as an invitee when you come upon the premises without implied invitation. You're not an invitee. It's pretty slick how this is drawn. It's pretty slick. It doesn't do a thing. When you really get through it, it doesn't do a thing. High crime area. Again, I think it was mentioned that this was an attempt to codify the case law. I think codifying the existing case law is the last thing you want to do. The reason we're here is the case law, as recognized by the Supreme Court justices whose hands were tied, the case law, they don't like what they had to do, but they did it, but they're begging for the legislature to act in a reasonable manner. This bill does not do that. High crime area is not defined. If under this, if the third-party tortfeasor commits a third-party tort and injures someone off of your premises, you still could be held liable. This is not limited to own your premises. It's not limited to that. Think about that. If it's a block down the street, are you responsible for that? I think in the Six Flags case, there was a problem in the park, but the people left the park, got into a fight, and some bad things happened. Six Flags was held liable when it didn't even happen on their property. So that's the crazy thing that you get here. Let me just suggest, and this is like putting lipstick on a pig, and I don't want to infer by any means that if some of these amendments are adopted, then all of a sudden we're fine with the bill and you should pass it. I don't think you should pass it, especially at this late hour, at this late time in the session on such a serious problem. But I would suggest to you on line 11, after occupier of land, you include and its employees, directors, security contractors, and independent contractors. That's number one. Number two, I would suggest that you add, after 53.1, you add 51.3.1, you add 51.3.2 and 51.3.3 to make sure you've covered everything. Even though, understand, even if you do that, the protection you're offering the property owner is so limited. You're only offering them protection if somebody comes on as a trespasser or if they came on the property to commit a crime. That's it. Everything else is fair game, and you could be liable for that. So again, that doesn't solve all the problems. I think it helps the bill, but it doesn't solve all the problems. I don't think you want to codify the case law. My suggestion for the amendment on line 20, actually 21, whether the premises or approaches are located in a high crime area, instead of saying may be considered, I would say shall not be considered. Strike may and insert shall not by the trier of fact to make that clear. Senator Walker, to your point on line 32 and some others who commented, apportion some percentage of fault. Again, I think that opens the door to say, okay, we're going to give them 1%, 2%, 5%, whatever it is, and then stick the people who've got the big pocketbook with the balance of the liability here. I would suggest the best I can come up with is apportion a reasonable percentage of fault, on line 33. I would also suggest that you add, I would think, and I'd defer to legislative counsel on this, but under after line 24, add a C to read something to the effect An owner or occupier of land and its employees, directors, and security contractors, independent contractors shall not be liable to a plaintiff for injuries incurred by such plaintiff which do not occur on the property owner's property. Limit it to their property. I mean, are you going to make business owners responsible for policing the entire neighborhood? How far does that go? 1 block, 2 blocks? I don't know. And here's the thing. You pass this, business owners have no more guidance than they've got right now. They don't know what to do. If they hire security companies, are they going to say, well, you didn't hire enough? If they're in a high crime area, does that mean, well, if I hire security companies, is that enough or no? Do I put in some lights? Is that enough or no? And here's the thing about the high crime area that I want to mention too. It says you can consider that, however, the mere fact that the premises is situated in a high crime area is not on its own sufficient to establish a duty. Well, all they got to do is say, okay, number one, they're in a high crime area, and then number two, they got to find one more thing. One more thing. Either the lighting wasn't good enough, or you didn't have enough guards, or you didn't patrol right, or whatever. It takes that much more to find liability. They're not giving business owners anything in this bill. Not one thing. Those are the amendments I would suggest to you, but I would strongly urge you to hold this bill. Let this subject be studied much more in depth over the summer and fall, and we can come back next year and do something that really moves the needle in a proper way and that is fair to all the Georgians. Ladies and gentlemen, don't allow yourself, if this bill passes, don't allow yourself to be fooled that you go out and tell your constituents that you did something about premises liability with this bill. They're going to tell you didn't, and you haven't. I'll tell you that. Business will know you haven't. Your constituents will know you haven't addressed the problem. I think it's very telling who all is against the bill and who's for the bill. And all we're asking for is a bill that moves the needle in a proper way, bills language that we offered during the negotiations time and time again, and this bill contains none of it. That's the bottom line. Mr. Chairman, with that, I'll yield for questions.
Did your group support the House bill as it passed?
Mr. Chairman, we agreed just to step down, the House bill, well, there were two bills. One bill passed out of committee, then there was a rule sub. We were vehemently opposed to the bill in committee, which I testified against.
Okay, what about this bill when it passed the House?
Which bill?
The bill we're
the House bill?
Yeah, 1371.
Not the sub, but what actually passed the House?
Yeah.
We just stood down. We didn't take a position on the bill.
What has changed now where you're now against the bill?
Because this sub is different from the House bill.
And what parts of the sub that has been added that makes you now oppose the bill?
Well, for one, the apportionment language.
Okay.
We had apportionment language that was offered, it was rejected.
I'm not talking about language you've offered. You were for.
This was not in the House bill.
Here's my question. In the House, you said you stood down, so I'll take that as no position on the bill. Now you're here. Hold on, let me ask my question.
Yes, sir.
You're here opposing it. I asked you what parts of the new bill. Now there's a sub.
Mm-hmm.
What's in this bill that makes you now oppose it? So you don't like the apportionment part. What else makes you oppose
everything
it?
I've just laid out for the last 15 minutes, we don't like.
But you agree with me that the parts of the bill you now don't like are in the bill that you didn't have opposition to before?
Mr. Chairman, we were never crazy about the bill that came out of the House, ever.
That's
fair. Why we didn't
I'm
support
asking
it.
these questions.
And here's...
Wait, hold on.
Let me
ask my question.
Okay.
You can answer my questions.
All right.
You say you weren't crazy about the bill, so you didn't support it. So I'm going to go back. Did you support the House bill? Did your group support the House bill?
No.
House bill. So you did not support the bill that passed the House?
No.
Okay. A minute ago you said you stood down, so now you were opposed to it.
No, you asked me if we supported it. I said
That's right.
no.
You said y'all stood down. Okay. That's
And
fair. So the other question then is
Mr.
there...
Chairman, can I finish just one thing I think is important? I think people will understand. The purpose of standing down was to allow the bill to move so that it would be a bill still alive that
Sure.
we could continue to work on to try to improve it to a point where we could support it. We had every intention of trying to come to some place where we could support it. We never got there.
Okay. Is there a version of premises liability of this that has existed over the last year that your group does support? There's
Yes,
been
sir.
a bill. And what's that bill?
You mean a bill's been introduced?
Yes.
No. The bill, well, no, I'll take that back. We supported 186.
Senate Bill 186.
There was a sub to 186. I believe I have the number.
And what is the status of that bill?
That bill is in rules,
Okay, so the bill got it. Which committee did that bill pass?
passed out of insurance.
Okay, and so that's a bill that your group does support.
Yes, sir. But I will say this. We were open to some changes in 186 and the sub. Again, to try to come to a reasonable, I don't want this committee to think we've been unreasonable in this process. We have tried and tried to come to a middle ground on this, and we don't see this as any kind of middle ground.
So a couple more questions. I'll turn it to others who want to ask questions. You mentioned several proposed amendments, but you then said, and correct me if I'm wrong, if we still adopted all these amendments, would you still be against the bill?
Yes, sir. This bill, yes, sir.
So if we took every amendment you just proposed, you'd still be against this bill?
Yes, sir.
Okay.
I don't think it would still get it to the point where it does any real good. I'm trying to perfect a very imperfect bill, but it still, in the final analysis, does not move the needle in favor of business.
Enough for your group.
In our opinion, doesn't move it at all. It may move it backwards because you're codifying bad law. You're codifying bad law. That's our strong opinion.
All right. Senator Gooch.
Thank you. Before I ask the witness a question, I'd like to ask the chairman a question, if you don't mind.
Sure.
I don't know how many more people we're going to have time to hear from tonight, but could you tell us who you've worked with on this bill so we know which parties have been involved in this?
Oh, I do. I have not had a single, I don't think, make sure I'm correct. I don't think I've had a single meeting about this bill, period.
Okay.
This is a bill.
Earlier, I thought you said you had coordinated some input from
No,
various groups.
I mean, I know that leadership in both chambers have been negotiating with the parties involved.
Okay.
And so I'm only privy to what I was told by those groups that have been negotiating.
So there's been no active input in creating the draft that we see before us?
Not from me.
Okay. Could I ask you a question?
Yes, sir.
On section 2, under the apportionment portion, on line 32, did you recommend an add on that, or what was your?
To change some to a reasonable percentage
Okay.
of fault.
Okay. Thank you.
Your questions for Mr. Edge. Senator Kennedy.
Thank you, Mr. Chairman. Mr. Edge, I had asked the question earlier, and I wonder if you could help. The language that's seen on, do you have a copy of the bill?
I do.
Yeah. That begins after the comma on line 33 that says, that after it gives the text that presumably provides some protection for landowners, which I agree with you, and especially as you have explained it, I don't think it does either, but it does only in the event provided that all the requirements of this code section are otherwise satisfied. And so this code section is 51-12-33, which is the apportionment statute. What effect does that clause after the comma have on what is being proposed when you read it in context with the apportionment statute in general?
I'm not sure.
I don't know either, and I don't know that we can determine any value to this, good or bad, for me, without someone who can say, when you read this together, this is what this means. Part of what's confusing a little bit, it's proposed as a paragraph on line 30 as paren D period 1 close paren, and the apportionment statute has an A, B, C, D, but it's a open paren, small d, close paren, open paren, 1, close paren. So I don't even know where this would be inserted in 51-12-33.
And Senator Kennedy, I'll go a little further on that. I've been doing this for a while, practiced law for 32 years, and been involved here at the Capitol for a number of years. Maybe there's language like this somewhere else. This is not common language, I don't think, to put in a bill, provided all requirements are otherwise satisfied. That's not something you commonly see, I'll say that.
Me either.
Any other questions for Mr. Edge? All right, thank you.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. One other speaker, Dan Snipes, Georgia Trial Lawyers Association. You are the last speaker, so close us out.
Thank you, Mr. Chairman. By way of background, let me try to address some of the things that have been brought up. GTLA was asked by Speaker Burns to sit down and engage on this issue. So this is not a bill we brought because it's something that we felt like we wanted to address. We sat down and engaged because Speaker Burns asked us to engage, and then since the bill passed the House, the Lieutenant Governor has also asked us to engage. So we have been engaged in this process, and as Mr. Edge pointed out, we have had a lot of negotiations, and we have not been able to reach a compromise. But because I gave a commitment to Speaker Burns that I was going to try to continue to work on this, I have continued to work on it. And we have continued to make proposals. We've just not been able to find common ground. By way of background, though, I think it's just very important. While the legislature calls this a premises liability case, premises liability is a broad area of cases where the people who have control over property can be liable to persons who are injured on those properties. Typically, a lot of those cases come in the form of slip and falls or things that happen where the condition of the property causes an injury, and that's a lot of what 5131, 5132, and 5133 address is the duty of care that's owed to various groups of people when the condition of the property causes an injury. And in the last 15 years, there has been a rise in cases of negligent security, and that is a part of premises liability that's very different than, I think, what existed for years. I think when everybody in this room that went to law school, that's kind of the nature of premises liability, were mostly slip and falls. This is something that has arisen mostly in the last 15 years, and right now it is exclusively case law. But because it's case law, there's a lot of things in Georgia that we rely on case law for. In fact, the standard that a landowner has for a slip and fall case is a Robinson v. Kroger Supreme Court case that's been the law for a long time, and businesses understand the law. They know how to file for motion for summary judgment, and they're very successful in those cases. In Georgia, the standard for when a product is considered defective is based on a Georgia Supreme Court case. There's a test set out, a risk utility test that sets it out. So there's a lot of places in our law where we rely on case law to give us guidance. In the area of negligent security, the law requires two things. One, there has to be a foreseeable risk of harm to a guest on the property. That's part one. It has to be foreseeable that somebody on your property could be hurt by a third party. And only when it's foreseeable, then there's a duty to protect against that, to take steps to protect against that risk of harm. But it's a two-part process. And Mr. Edge kind of conflated something there that's not right. You have to have both of those, okay? And so in going through this statute and in trying to address some things, the first thing this statute attempts to address is to say there are a group of persons that can't bring these cases under any circumstance. That's the first thing it attempts to do. If you're on the property to commit a felony, for whatever reason, if you go in there to buy a pack of gum but you intend to rob somebody in the parking lot, you can't bring a case. If you go in there if you're shoplifting and you're doing something and you get hurt by a third-party criminal act, you can't bring a case. The reason, that was the House version. The Senate version was expanded slightly to make sure if you're a trespasser or a loiterer, you can't bring a claim. To answer Senator Kennedy's question, the reason, though, it was kept to not all crime is specifically the instance of if there's a young lady who's drinking underage in a bar, that does not mean that because the bar has knowledge, and they have to have knowledge, that their customers are being sexually assaulted, and they take no steps to prevent that type of sexual knowledge when they know about it. Just the mere fact she's drinking underage would not prohibit her from bringing a claim. So that's the reason why that was crafted in that way. So there's a class of people who can't bring it. And then on the foreseeability part of it, okay, right now in Georgia law, you look at the totality of the circumstances of whether or not it's reasonably foreseeable. And what this is saying is that merely being a high crime area alone is not enough. And it is a change from where the law is currently. Because right now you look at all factors, and there could be a circumstance where if the crime was enough in the area and bad enough in the area, that could be enough to create this duty of care that wouldn't exist otherwise for third-party criminal acts. So this says that just that alone. So that does move the needle some. Is it as much as it could possibly be moved? It's definitely not. It moves it some. And then the last part of this is that it requires that a jury apportion some degree of fault to the third party. And in the CVS case particularly, because of some parts of that case, none was apportioned, but this would address that. And it would say some has to be. Now, the difference in, and that's a question of fact for the jury. But that's also where lawyers have an obligation to represent both sides of the case and point out. In the cases, though, where large amounts of fault are apportioned to the occupier of land, it's because the occupier of land had extreme amounts of knowledge of a risk of harm to their guest, and then they didn't do anything at all when they had that knowledge, and they didn't take any steps to protect their guest. And that's the kind of situation where juries, the people that vote like I do and vote for y'all and are eligible to serve on juries, that's where they say, in light of the facts of these cases, the harm is attributable to the party that had knowledge this was happening to their guests and chose not to do anything about it. And while you look at the fact these things happen sometimes, when you sit down and study it, jurors are making decisions based on the evidence before them. To go to Senator Kennedy's question, I think the comma provided that all requirements of this code section are otherwise satisfied means that the defendant would still have to provide the notice required under the code section. They just couldn't pop up at trial and say, all right, you've got to apportion fault to the third-party criminal. They still have to provide the notice requirements because that's what it is. I think that's what it's trying to clarify there. And that's my best answer to you on that. It's very important, though, that, and to go to some of the specific things that were mentioned. On line 21, where I think Mr. Edge said it should read shall not as opposed to may. Right now, you've got a circumstance, though, where it's totality of the circumstances, and being in a high crime area alone could be enough. But when you're looking at a situation like this, okay, and let's talk about a situation where one business is in a shopping center, and they're next door neighbors, and I'm here and we share a common wall, but we rent from somebody and things happen in the parking lot and things happen next door to me. I've got an obligation to be aware of what's happening next door to me. I have to have knowledge of it, but if I know that my neighbor's having a crime problem and I don't do anything, that's not reasonable behavior. If I know that crime's occurring in the parking lot that may not be my property, that's not reasonable, though, if my customers are using that property to access my store. And when you rent, when you're renting commercial space, you may just be renting Unit A and Unit B next to you, and the owner maintains control of the parking lot. You may pay a fee to have it cleaned, but it's not your property. And when you start trying to limit it to just that property, in an urban area particularly, you run into a lot of things where parking lots are owned by different people. Businesses share common walls and they're next to each other. And it should be, you have to consider the things that go on around you, because if you don't, then you're creating an incentive for people not to try to know what's going on around them. And that's the reason why, does this go as far as things could, but that part represents a fair compromise. On the example of trying to include subcontractors in security companies take on a duty to do something, okay? They're assuming a duty that they do for pay. And this statute protects the landowner and occupier of land, the lessor and the person who's running the business. But when they hire a third party to do a job, this statute should not provide a protection for somebody who's hired to do a job. And I'm just not aware of where any employees have ever been sued for something like this. It's the businesses that are inviting the people onto the land. The employees aren't inviting anybody onto their land. They're there, selling drinks or whatever they are. On line 32, what's that? On line 32, real quick, on some encapsulates the same thing as reasonable. It's requiring a jury to put some degree of fault on the third-party criminal act. I respect Mr. Edge immensely. I think he's done a great job for his clients for a long period of time. He's done a great job for them in this. What this represents, though, is an attempt to move the needle some. And it does move the needle some. And it does not make it go in any way but towards the business community, and it's trying to help some, and it tries to help create a standard by which lawyers who are good lawyers can then try to limit evidence and try to move the needle further.
You have questions, Senator Calvert?
Thank you, Mr. Chairman. Mr. Snipes, appreciate your efforts on this. I just want to make sure I understand. On lines 13 and 15, these grand exceptions that are now being made to this bill only apply if the plaintiff, the person that's hurt, that's suing the business, was a trespasser or is a felon himself.
Or they're to commit a theft crime, but that is saying they cannot bring a case. They cannot bring a case at all.
Well, no kidding. They're the criminal. They're the problem that's hurting the innocent people here. I don't follow this where the plaintiff came upon the owners or off premises without express or implied invitation. Well, businesses expressly invite or impliedly invite everybody. They want customers, so you can't. I don't get. I mean, these are such tiny exceptions. It would require some complete trespasser at a public place that's open for public, or else a felon that is now saying, y'all owe me money because I got hurt committing my felony. This is absurd. Those aren't even exceptions. Or are they? I mean, you are talking about the plaintiff is the hurt person.
That expressly prohibits those types of claims right now.
Are we seeing cases where is that why the business community is crying for help? Please make these criminals that get hurt while they're committing a crime stop suing us?
I think that has been some allegations that some of the parties that have engaged in some of the cases were engaged in various types of criminal activity, which this is trying to address. It also gets into, beyond that, lawyers and people who are hanging around and not there for a business purpose. Okay.
Second question. So what you have pointed out to us is we don't have a statute other than these general premises liability statutes. We don't have one directly for cases where somebody gets hurt by criminal activity. That's all basically common law. The judicial hellhole came up with that law. And that's why we're trying to pass a bill to rein this in somehow. I mean, right? Don't we agree that that's the body of law was not some statute? We never had one. This is law that courts created establishing liability against businesses.
I first just disagree with the premise of judicial hellhole and where that comes from. But beyond that, there's not a statute that addresses that currently. The CVS v. Carmichael case that the Supreme Court decided this past summer right now is the controlling law as to landowner occupier of land liability for harm caused by third-party criminal acts.
Right, court, common law.
And this tries to move the needle somewhat back towards the business community.
Is it Senator Harbin? Yeah. Senator Harbin.
I think one of the things that we need to realize is that if Georgia is to remain number one in business, there will be a change one way or the other. When I talk to major insurance companies that are looking at Georgia as a bad place to do business, they have other states to do business. If we do not take some action to ensure them that we are making changes, I think we're going to continue to see the markets dry up, excess liability, other things, and our businesses cannot continue to do business if they can't get that. And we are seeing that now with limits and what's going on. I'm listening to the attorneys go back and forth on both sides, and y'all neither one make the decision. Well, who makes the decision, is my understanding, is the jury that's there, and they listen to the two sides come at each other, and they make the decision. And many times they are limited in their knowledge of the law. But what I see is that this doesn't move the needle a whole lot. And what I think is this is for us not to do something, we are negligent in our duties to the business owners and to the citizens of Georgia by not doing something and realizing that if it's not done, businesses, insurance businesses specifically, will go somewhere else. And that is a concern that I have when I see this. Just some of the little bitty things that are here are not sufficient to cause companies to say, I want to come to Georgia. I know that Florida has had major tort reform in their areas that have opened that door, but they got other problems in the property areas. I just see this as that, as I hear both sides going on right here, and I realize that juries ultimately make decisions. Am I correct on that? Most of the time they're listening to both of you and they're making decisions. There's just not clarity, and this is not, doesn't seem to be moving that needle really a whole lot from that standpoint.
I guess to address the point you're trying to make, I think when you look at like what you have in the law that has developed since the Supreme Court case and slip and falls in Robinson v. Kroger, and there's a well-established body of law there, and quite frankly, it's pretty favorable for defendants in those cases. And I think by taking the CVS case and then trying to move the needle some, it creates a circumstance where you have a more established body of law, but we do have a much more established body of law, and I think good lawyers who defend these cases are going to start having a way to, I think, craft better defenses using the facts of the case. But then in some of the facts where they're just egregious bad conduct, where you know you have a problem and you choose not to do anything about it, there's still going to be liability for landowners for third-party criminal acts, as there should be.
Okay.
I'm lobbying my members to stick around after this. We have more bills. I'm working on that, trying to keep people here. Everybody's going to leave when this is done. We will be really quick with the rest of the agenda. I know this is important. Everybody has a right to be heard on this. There are several other measures after this. I'll keep lobbying y'all to please stay for like 10 more minutes when this is done. Senator Dolezal.
Thank you, Mr. Chairman. Thank you, Mr. Snipes. I appreciate you laying this out for the people in the room who are not a lawyer.
Did you pay the first time too?
No, I still owe. Gooch only has so much money in his
give
wallet.
Money.
So.
Yeah, he's limited. Gooch is actually limited. All right.
Mr. Snipes, I'm curious, a couple different things. One, in your mind, can you conceive of a case where there is a third-party negligent claim due to a violent crime that is inflicted on a person where the landowner, not the person who committed the crime, is 99.9% liable?
Well, I guess I can, and let me try to go through. If I'm allowing parties to engage in dog fighting on my property, and their dogs are routinely getting out and attacking somebody, and a child is mauled by a dog, that I'm allowing the people I have.
Can you give me an example where the landowner is not committing a crime? Because dog fighting is illegal.
You asked me to come over the case.
Sure. Okay.
So the case. That's the first one that popped in my head. So it's got to be a case, and that's what I'm thinking out loud. It's got to be a case where the landowner has an extreme degree of knowledge that is incredibly egregious, and it has a very high risk of harm to it, and that the person is allowing it to go on. So, all right, I'll think the example would be that a hotel owner who is turning a very, very blind eye to sex trafficking, and he knows that there's sex trafficking going on in his hotel, and he's not committing a crime, but he knows it's going on, and then a young lady is brutally raped because he refuses to do anything about it, even though he's going on. I could see where a jury would get mad enough in that case that it should be 99.9% of the fault on the hotel owner, particularly when he's renting a room by the hour.
Okay, so 0.1% to the rapist.
Yes.
The person who's in the room by himself, inflicting that crime on the female, and 99.9% to the landowner.
Yeah, I'll go with that. I'll stick with my example.
Okay. Would you be favorable to an amendment to this bill that allows the trial court to adjust the percentages in the instance that the jury would to come to something that you and I could both agree was a percentage that was punitive to the landowner, not reasonable?
I think a judge already has the ability to do a lot of different things with verdicts post-judgment. I think they can they can enter a judgment notwithstanding the verdict. They can demand a retrial, or they could, there's a lot of things they could do post-judgment where a trial judge already has the power to do the things you're talking about.
Would you be open to codifying that in this law that specifically addresses the apportionment portion of these cases?
I think the appropriate thing to do would be to look at the statutes that already allow a judge to do that and see if they need to be expanded in some way.
Okay, which leads me to my next question. Given the fact that we're here on day 38,
yes, sir.
Given the fact that we had a bill on the floor today where the governor has basically said, let's take a year and look at kind of the tort environment in Georgia in general. And I don't know, is your organization taking a position on the governor's bill as it relates to that?
Well, quite frankly, in talking with the governor, we appreciate the fact he's going to look at it, and we hope to have a seat at the table.
Okay, and I would hope that you would as well. With that in mind, do you think that the wise thing to do would be to set this aside for the time being, allow that work to continue, allow you all to have a seat at the table, and revisit this after that data has come in, and perhaps after there's been more time to discuss it between you and Mr. Edge and other interested parties?
I'm not wise enough to make that decision because Speaker Burns and the Lieutenant Governor have both asked me to engage on this, so that's the reason I'm engaging, and they're wiser than I am.
Thank you.
That's a good answer.
He is a lawyer.
Yeah.
One thing I would like to tell the committee to address, I think the concern that Senator Dolezal and Senator Kinney made, I think it would be appropriate to amend lines 11, lines 20, and lines 30 to say Code Section 5131, 5132, or 5133. I think that would be appropriate, having heard the questions of the committee.
Right. Let's see if we get to that point. Leader Gooch.
Yeah, and I've refused to put money in this jar, so I'm not going to say.
Just save the line. It's late anyway. Come on.
I just want to ask a simple question. How do you think, in your professional opinion as a lawyer, that we have gotten where we are today in Georgia? We're the number one state to do business, but obviously no one uses our legal our tort systems as part of that criteria to determine our number one status. But we are on the judicial hellhole list as number one, being the worst. How do you think we got to the top of that list? Can you share your thoughts on how a state would get to that point?
Well, the judicial hellhole list is from an organization, the American Tort Reform Association. And if you're a hammer, the whole world's a nail, okay? And what they're addressing is the fact that there are some very good lawyers in Georgia, and there have been some cases that involve some very egregious facts that have led to verdicts that are, very large, but they're verdicts driven by corporate misconduct and horrific injuries. And that's one thing. And then the second thing I think that the American Tort Reform looks at is they look at, when they have tried to, the U.S. Chamber of Commerce and other organizations have tried to push legislation that has been unsuccessful. It's a way of them voicing their displeasure. And the judicial hellhole report is nothing more than a propaganda piece to try to incentivize lawmakers to pass laws that are hurting injured persons in favor of big business. And that's what that is.
So if it's propaganda, why did they choose Georgia as number one?
Listen, y'all, this is not part of the bill. Y'all can go all night
no,
about
I wanted
this.
I wanted to just.
Well, can we stick with questions about the bill?
I will try.
Mr. Leader?
I will.
Because it's late.
But
versus
I wanted to know. I wanted to also ask
you,
what involvement did you have in drafting this bill? Any input?
We sat down with Whit Burchett, and Whit Burchett, though, came up with the structure of the bill, and he's the one that came up with the bill that went to committee and the bill that went to the House, and then subsequently we have been working with the Lieutenant Governor's office on the bill. But I did not draft the initial House versions, and have been working with the Lieutenant Governor's office on discussing this substitute language.
Thank you.
All right. Questions on the bill? Senator Sutz, ended that up about the bill? All right, about the bill.
I just wanted Mr. Snipes' opinion on two quick things. Whereas on the one hand, it's persuasive that this idea that people are, you shouldn't be accountable for folks off their property. I think about things like sports events. You've got if I use an app and I'm going to go to a game, the app shows you parking that's around a big area, maybe a mile or 2 miles across that you're parking, and you've got the $40 parking here and the $20 parking there. I mean, from the standpoint of what is the state of the existing law? If I'm going to a big event that there's a draw to, whether it's a concert, whether it's sporting event, and I'm parking on one of the outerlying parking areas, and I'm coming in, does the sports team have some liability for that?
Well, I think it would deal on two different things. One is if the sports team is the one designating the area to park in, they would. But if a private citizen or private business has their own lot that they're doing something separate from the sports team, the only person responsible for that would be the business that's operating parking that is somewhere near the venue. But as long as it's not affiliated with the sports team wouldn't. It would be the person that is inviting people onto his property to park and then go to wherever.
Yeah, I mean, and I just asked the question because the facts in the Six Flags case tend to kind of make your ears tingle a little bit. But I mean, when you think about this, is the circumstance of having liability for things happening off your campus, does it happen a lot, or is it pretty rare that it happens?
It's extremely rare. The Six Flags case was very unique because that incident started there and then went somewhere else. But the activity that occurs away from your property is what puts you on notice of a risk of harm to your guest. But the risk of harm to your guest has to be something that originates on your property or on the approaches to your property.
Okay. I just asked a question, Mr. Chairman. These aren't leading questions. Because we're trying to weigh this out as members of the committee and kind of balance this. And I just, you hear these cases, and we're trying to assess the significance in which, how often are property owners assign responsibility and pay settlements for things that happen off their property? If it's a relatively narrow set of circumstances, is it common? Is it not? I wanted some context for that.
Extremely rare. And this is this is a public safety concern. The cases arise where there's public safety issues.
Thanks.
Before we do that, any other questions from the committee? All right, that's everyone. It's time to speak. Let's see what the committee wants to do. What's the pleasure of the committee? Senator Kennedy.
Thank you, Mr. Chairman. I appreciate your patience with this bill that's got us all perplexed on an issue we've dealt with for a long time. I would make a motion that we table this.
We have a motion to table the bill. Is there a second? Second from Leader Gooch. So at this point, let's just move to a vote on it. All those in favor of tabling the bill, raise your hand, leave your hand up so we can count. It is 7. All those opposed, please raise your hand and leave them up.
5, 6, 7.
It is 8. The motion fails. Any other motions from the committee? Is it Leader Gooch?
I'd make a motion, do not pass.
Second.
House Bill 1371, LC 442839S.
Y'all gonna try to test my parliamentary skills, aren't you? Motion do not pass from Leader Gooch, a second from Senator Kennedy. All those in favor of the motion do not pass will raise their hand. 1, 2, 3. I sense a trend. 7. All those opposed. Appears to be 8. The motion fails. Any other motions?
Did you ask for the no votes?
The no votes on the motion do not pass. Do not pass. Raise your hand again. All right, let's make sure we're all clear. Senator Gooch had a motion that was seconded. It would be a motion recommendation do not pass. All in favor of the motion from Leader Gooch, please raise your hand. 1, 2. All right, 7. So all those opposed will now vote. to the motion? 8. All right, motion fails. Do we have any other motions from the committee? Do we have a motion to pass from the committee? Motion to pass from Senator Cardin Summers. Is there? Let's see if there's a second. Is there a second? Second from Senator Jones. This will be discussion. So, Senator Bearden.
Getting late. I believe maybe it was a suggestion to amendment discussing lines 11, 20, and 30, adding.
Now would be the time for amendments. We have a motion to pass and second, so we are in the place we can do amendments. What is your amendment?
On line 11, let's see if we may just have to do this one line at a time. On line 11, after land shall not be liable under code section 51-3-1, insert comma 51-3-2 and 51-3-3.
Would it be comma or? Okay. You would do the same thing on
line 20 and line 30.
Okay. Does everybody understand, before we ask for a second, understand the proposed amendment? Is there a second for the proposed amendment? Second from Senator Setzler. All those in favor of the proposed amendment will raise their hand. Maybe this will all be on the same page. It is unanimous. All right, the amendment is on. Any other amendments from the committee? All right, we're back. We do have Senator Setzler. Okay, this is for amendments. Is it Leader Gooch? Okay. Senator Dolezal.
I've got a couple I'll try here, Mr. Chairman, if it's okay.
Okay.
I'm, given what we just did, I would move that we strike lines 13 and 14.
What was your...
Second.
All right, so you would be striking, I'm sorry, I was distracted. Striking what lines?
Line 13 and 14, which say where the plaintiff came upon the owner or occupier's premises or approaches without express or implied invitation.
So would you then be renumbering the 2 on 15 to 1?
I would.
I don't know from drafting.
We may not even need a number 1
Yeah,
there.
You'll strike the 2, yeah.
Yep.
And you'll also strike the semicolon from line 12 at the end.
Correct.
The corresponding amendments, right, that go with that. Okay, is there a second for the proposed amendment? Second from Leader Gooch. Can't even say your name anymore. Any discussion? Is this discussion or other amendments?
I have an additional amendment.
Well, there's other lights on for the committee. I think that's one's Leader Gooch and one is. Do you have? Is it discussion on this proposed amendment or something else? Okay. So the amendment would strike lines 13 and 14. Is it discussion? Yeah. All right. Senator Setzler.
I just have a question for the author of that amendment. What's the thinking behind that, and what's the? I mean,
so essentially, in my opinion, lines 13 and 14 define an invitee. When we just added to amend 3.2 and 3.3 from Title 51, from Code Section 51 there, that we are also including licensees and trespassers, and really what we're then codifying, which again was what makes this bill frankly really goofy, is we're saying that an owner of land shall not be liable to a plaintiff for injuries incurred by the plaintiff arising from third-party criminal activity where the plaintiff came upon the owner or occupier's premises or approaches for the purpose of committing a crime punishable, and then we get into where we're at. So, which I think is frankly why this whole bill is should be set aside for the moment, because we're essentially, as Senator Cowsert laid out, we're creating this statute where a landowner is not liable to a plaintiff, a person suing them, when the plaintiff came on the property to commit a crime.
I just asked the question. I mean, there's some effort to balance these things. I don't know that works to the benefit of the landowner. I think this is a circumstance where the landowner has protections, and by removing 13 and 14, you're removing protections.
Can you define what you think the protection is?
I mean, if you have someone that's trespassing on the site, there's not expressed or implied, invitation. Any trespassing and any similar such activities, you slip in at night, the place is closed, it's after hours, you're prowling around. Those circumstances, I'm not the best equipped to address those, but it seems to be that you're eliminating an immunity that exists that would be a benefit.
An owner or landowner, just called an owner. An owner shall not be liable to a plaintiff where the plaintiff came upon the landowner's land with permission. We are now including sections 2 and 3, which includes which includes licensees, which are participating in, call it approved behavior, but maybe they were not invited to do so. And I've referenced my past life where we would have buses that would meet in a parking lot, right, and to leave. So I think that you're innately defining invitee here, while we just made an amendment to include licensees.
I'm just saying, if the person that's on the property is not an invitee, they're not going to be a customer, they were just sort of maybe in another part of the parking lot that's not really relevant to the business, or they're just, or some, they're in proximity, and they get harmed by somebody else, they weren't an invitee customer to the business, then by removing this, the immunity that the landowner would have
Further discussion
is removed. I mean, I don't know that it's helpful.
All right, it was seconded up. Was there a second?
I'll withdraw if that's where the contention is. I'll move on to my next amendment.
Okay,
okay,
let's
Mr.
move on to your
Chairman.
next one.
I move that we amend line 32 by striking the word some and inserting in its place at least 50. I'm sorry, I'm going to strike some percentage and replace it with 50%.
So they shall apportion 50%.
At least 50%. Let's say that.
I think that's it was just pointed out, the plaintiff then cannot be found more than 50% at fault. That would be the implication of that. But that may be your intent, but. All right, it was seconded by Senator Calzert.
The way that it would read then is that, let's just make sure we get this right. For injuries arising from third-party activity under code section, try a fact in making apportionment of damages under this code section shall apportion at least 50% of fault to the third party that committed the criminal activity.
In every case. Okay. Mm-hmm. All right, there's a second for the proposed amendment from Senator Calzert. All those in favor of the amendment, please raise your hand. 1, 2, 3, 4, 7. All those opposed? Nobody's thinking outside the box. 8. Amendment fails. Any other amendments? Senator Dolezal, move on to others.
No, it's okay.
All right. Leader Gooch, do you still have amendments? I appreciate you. Someone on this side does have an amendment. Who is it? Now, you're new to the committee. You wave. All right. Whatever's left of the bill, wherever we are, we're back to a motion to pass. I'm sorry? We have... All right, let me recognize you, sir. You're Mike 15?
Sure.
All right.
Is on line 32 again, strike some to reasonable. I think it's the same thing, but does that help?
So you would replace some with reasonable?
A portion.
Is there a second?
Probably a reasonable.
Would it be Mr. Walker shall proportion a reasonable? Would that be the way of putting it? Okay, is there a second to the proposed amendment?
I'll second that.
Second from Senator Calzert. All those in favor of the amendment, proposed amendment, please raise your hand.
10? Did you get 10?
We-
11. Okay. Sorry, put them back. Can y'all keep it? Sorry.
Yeah, leave them high. Don't do the Schaefer hand raise. Sorry, it's late. I'm gonna get honest.
11, yeah.
11. All opposed? 1, 2. I'm gonna count. 4. The amendment carries.
I had a parliamentary inquiry. This is a hinge point of this bill. I don't think anyone wants unreasonable things to happen. Nobody on this panel wants unreasonable things to come out of this. What I want to understand, though, is this is an important hinge point of this entire bill. What is some? I understand some could mean a de minimis amount. That's almost nothing. What instructions is the jury going to get with some? Is reasonable something that's used in this context in civil proceedings?
I hear you. The amendment carried, if I hear you. Yeah.
Well, but before I make a motion to reconsider, I just want the committee to understand this is a.
Everyone, hold on.
Guys, hey, listen.
Hold on. Hold on.
Good question.
I know it's late. Hold on. I know it's late. I know everybody's had a long day, but let's try to remember decorum. This is still serious stuff. We make jokes because we have a stressful job to do, and it's our way of dealing with that sometimes. But I ask members of the audience, please refrain from any outbursts whatsoever. Let us try to finish doing this job. And if you can't refrain, we ask that you please leave. Senator Setzler.
As a member of the business community, 11 o'clock is, I'm still in my stride. This is not late. We're doing serious work.
I agree.
I don't know what other folks do for a living, but when you're in business, you have no boundaries on your time. That's why we care about it. No,
which is why y'all all stick around for the rest of these bills after this vote.
What I want to understand is no one here wants something unreasonable done. What I don't know is what is reasonable a word in these kinds of proceedings that's a word that's going to be clear to give juries instructions? Are there better words for that? I don't have a context for this. It's an important part of the bill. I just wanted to ask, is there awareness on our panel of what we've done?
So the appropriate thing to do to be offer another amendment, or you can move for reconsideration of the vote if you want us to look at that again at this time. All right.
Is there anybody here that, can we speak to a witness that's spoken to this that can clarify that?
Does anybody want to discuss that?
I don't want to be, I don't want to be on the side of doing
Senator
unreasonable things, but I want to understand what we're doing.
Senator Hatchett.
So I think the question that I have is there any other place in the civil code that requires a jury to apportion fault to a certain person? And what we just did was we changed it. Now, if a jury thinks that it's reasonable to apportion 0% to a third-party criminal, and they apportion 0%, now that's okay. But what we did, what the language was before was, hey, jury, you have to apportion fault to a third-party criminal. So I know my friend was trying to work with Dolezal, and I mean, I think he made it worse. I think it's better if you say you have to apportion fault to the criminal and not just a reasonable amount, because I know there are instances where, especially in negligent hiring, sexual assault cases, things of that nature, where a jury may get mad at the owner and put all the percentage on the owner because they may have known some things that and should have warned people. But I think it should have. I think it was stronger to keep it as some instead of just reasonable.
I think procedurally the best thing for us to do, if you want to change that back, is to offer another amendment this time that would go a different direction and amend what we just did versus moving to reconsider and then potentially having an amendment. Does anybody want to offer an amendment to address the line at issue? Dr. Watson, come get a microphone. Welcome to the party. You're a hold on, mic 2 or 3? 2?
Mic 2. I
right.
woke up over here.
Yeah.
I'm thinking out loud as Senator Setzler's talked. taught me how to do.
It's dangerous.
So reasonable, I agree. Reasonable may be 0. Some does mean something. 50% may have been too much, and I'm thinking out loud. Is there another percentage that would be reasonable to do? He said at least, but before it was at least. Your number was 50%. I'm throwing out a number is 30 or 40%. Is that something that moves the committee? And is that is
You're not hearing a lot of movement on that.
Yeah. Okay. All right. Then all right. I'll chalk that up to discussion. Thank you.
Does anybody want to offer an amendment to address the amendment we just passed? Senator Parent, you mic 6.
Yeah, since we're all just kind of thinking out loud, I mean, it could say a reasonable percentage, comma, which shall be more than 0, comma.
Okay.
Just an idea.
Is there a second for the proposed amendment? There's no second for that.
Just, again, thinking out loud.
Do you want to repeat it one more time? Because Senator Hatchett didn't hear you.
Oh, I said that, I think you're right, Senator Hatchett, that it runs into, some people could interpret the sum as being stronger in the sense that you could not be at 0, whereas reasonable could be argued either way. So I just said we could go back, we could keep it at a reasonable percentage, comma, that shall be some portion more than 0. So then that it has to be more than 0. Or you could just go back to some. But if people really like this reasonable standard, that way, thinking out loud.
Are you offering that as proposed amendment, or you want to see if somebody wants to?
Actually, yeah, I'm kind of curious. Thoughts? I'm not,
Okay. Everybody has pushed their button, so let's just work our way around. Senator Cardin, Summers. I can call you Senator Cardin. Senator Summers.
Mr. Chairman, what's that deal about the dollar now?
Anybody that speaks after 11:10 has to put $1 in the bucket. How about that?
Here's the deal. I'd like to take the bar exam if you don't mind.
Yeah. You're halfway there.
I'd like to offer an amendment to put it back the way it was, Mr. Chairman, if that be approved.
We have an amendment to put it back like it was with a second, and put it back like it was to look like line 32 of the existing bill. I think everybody's clear on the proposed amendment. It's been seconded.
Is this a motion for reconsideration?
No, it's another amendment to go back. It would save a second vote. A reconsideration, it would go back to what it was before. All those in favor of the proposed? Yeah, if you want. Do you want discussion?
Back to the reasonableness standard. That is prevalent throughout civil practice. That is tort law. That's what the jury's determined. You are only negligent if you did not behave as a reasonable person would have under the same or similar circumstances. That is the jury charge. So in this case, the landowner, that's what they're saying. They didn't take reasonable steps. That is left to the jury to decide. It is also, this 50% level is extraordinarily common. When a plaintiff is suing and they are found to be 50% or more responsible, they are barred from recovering. That's called contributory negligence or comparative negligence. So these are very common standards, and what Senator Dolezal proposed on this is the same standard you would use if both parties were at fault in a car wreck. If the plaintiff that's seeking recovery is more than 50% at fault, or even 50%, they can't recover. So I don't think this is a stretch in any way to say if the criminal wrongdoer is at least 50% at fault, then you can't recover against the property owners. I don't think this is some wacky random number. It is very consistent with tort law.
Any further, if you have more amendments, turn your button off. If you want to discuss this amendment, please leave your button pushed. Senator Setzler.
And my question to Senator Cowsert was, isn't the standard today, without this being codified, isn't the standard a reasonable standard? I mean, and I'm just an all shucks question. I mean, if the instructions are to a jury, establish reasonableness, there's no duty to say some. We have reasonableness today that got us here. Reasonableness doesn't change anything. It just codifies what we're doing now, which apparently is not satisfactory to some.
Just leaves it in the